Much for watching Law School Made Easy at Law School Made Easy 256. We want to thank you for always sharing and liking our videos. Today we want to look at the capacity contract in contract law. In our previous lectures, we have discussed the elements which form a valid contract. Section 10 suggests that there should be free consent, that somebody should enter a contract when they are not coerced. It is a free will to enter into a contract. And Section 10 further say that there should be an offer. There should be intentions to create legal bound. There should be acceptance. And finally, there should be consideration. But also capacity is in there, that you must contract with somebody who has capacity to contract. The Contracts Act clearly defines someone who has capacity to contract, that somebody above the age of 18. That is what the Act says. And further, re-echoes what the Constitution says in Article 34, 4 and 5, that also somebody above the age of 18 can contract. Now, you cannot enter into a contract with somebody who cannot contract. Let us first see who are the people who cannot contract. Number one, somebody who is mad, unsound mind. They are clearly defined in Section 12 of the Contracts Act. If somebody is of unsound mind, then you cannot contract with that person. However, there are exceptions to somebody of unsound mind, that we have lucidity intervals, that there are times when that person is normal and then he goes off, is on and off, on and off. So we are saying those people cannot contract. Another category of people who cannot contract, those are the people below the age of 16, the minors. You cannot contract with a minor because they have not reached the age of maturity, the age at which they can distinguish that this is a contract I can enter in, or this is a contract I cannot enter in. So at common law, contracts made with minor were voidable. And when we say that a contract is voidable, the take home is that it is now at the will of the other party, the minor, to either ratify it or confirms it, affirms it, or cancels it when they reach the age of majority, or when they reach the majority age. So you can see that at common law, contracts made with minors were voidable. Now, but we are saying in capacity contract that even minors can contract. Minors can contract, but there are different scenarios and circumstances under which a minor can contract. If a minor is contracting with somebody and the contract is about apprenticeship, is beneficial to the life of a minor, then at that point a minor can contract. But if that contract is not of service, that a minor is not benefiting from it, then a minor cannot contract. Now, let us first look at the case of Robert versus Gray. Now, Robert was a billiard player who contracted to teach this minor how to play billiard. They would move together to all the tours, but in between, they got a misunderstanding and the minor dropped the contract. Now, court held that a minor was liable because what Robert was doing was giving a minor a service, was teaching a minor something new. If a minor is being taught something new in terms of service, apprenticeship, beneficial in the life of a minor, then a minor is liable. And in this case of Robert versus Gray, Robert the plaintiff was awarded £1,500 as damages for the minor having terminated the contract, yet the contract was beneficial to the minor. However, where a minor is being given, let's say, where a minor is being given a contract, say, of service, a contract, a beneficial contract, and the conditions under which the minor is operating are harsh to the minor, even if it is a beneficial contract, even if it is the contract of necessary, even if it is a contract of service given to the minor, then the minor is exonerated from liability in that contract. Let us take a case of far sweat, the spelling disturbs versus Smith-That. Now, first sweat, the spelling is Fawcett versus Smith-That, Semthurt. Now, in that case, a minor, the plaintiff, now the minor, hired a car to transport his things to another place, to another destination. But in the contract, the owner of the car told the minor that whatever damage, whatever problem we get on the way, fuel is done, tires, you are liable, you are supposed to pay for them. Now, a minor entered that contract, but it was held that that contract was harsh to the minor. It was very harsh to the minor, to the extent that the minor was being told for any damages along the way when they are traveling on the car, it was the minor to pay. So that case was decided in favor of the minor because the conditions around the contract which the minor entered in were harsh and not favorable for the minor. Now, we need to pick the principle which was laid in Nash versus Innerman. The principle is very clear that the person supplying the minor must find out whether the minor is adequately supplied. For example, if a minor came and bought things from your shop and takes them, it is the duty of the person selling the things to the minor to find out if the minor is adequately supplied. That is one. Two, if the things the minor has taken are necessary in the life, in the condition of a minor at that particular time. Where you fail to do that, a minor is not liable. Let's take another case of DeFrancisco versus Barnum. Now, in this case, a 14-year girl entered a contract with DeFrancisco, and this contract, DeFrancisco, was to make tours, I think to sing with this lady. They moved together. The lady is trained out to do business. They go together for tours, and in that contract, it was made clear that a minor was not supposed to get married at the time when they were still in the contract. Number two, that a minor would be sent away at will whenever DeFrancisco wanted. They would not consult a minor at any time. They would send her away. Now, court still held that this contract was unfair to the minor. The minor was now disposed to absolute will of Mr. DeFrancisco, that the minor could not do anything, that the contract was harsh, uncomfortable for the minor, because now they are telling her she's not supposed to get married, she's in that contract, she's like a slave. So therefore we are saying that where contracts are made with minors and the conditions around all those contracts are harsh, unfavorable to the minor, a minor is definitely exonerated from liability. However, we are saying that where there are contracts of necessary, the minor shall be liable. However, there are things you must prove for the minor to be to be liable for any of the contract they have entered in. And we have agreed in number 1 that you must prove that the things supplied to the miner were adequate, that the things supplied to the miner were favorable and needed in the condition of a miner at that particular time. You must also prove that the miner is either not adequately supplied or was adequately supplied. So that is the duty of the person who is claiming, who wants to hold a miner liable for not fulfilling any of the contracts they have entered in with the miner. So that is capacity to contract for a miner. And then earlier I discussed the unsound mind, but now we can discuss fully the unsound mind. That we are saying contracts made with people with unsound mind are not right contracts. You should always wait. There is a scenario in section 12 that says lucidity intervals, that somebody where they are in their lucidity intervals, when they are now normal, you can contract. When they go back to, say, being mad, then you don't contract. However, contracts made with people of unsound mind are not valid at any one moment, because it is believed that that person do not understand or do not even know what is good and bad. They cannot differentiate on what they are signing. So the contracts of unsound mind are prohibited. You can only make a contract with somebody who has sound mind. You can even borrow if you want. Section 11 of the penal code that clearly talks about insanity, making contracts with people of unsound mind. It is not accepted at all times, at all costs. So that is capacity to contract. And then also under capacity to contract, we look at capacity of corporations. Corporations, how do corporations operate? And here we shall pick in simple principles. Number 1, that in the olden days, if a company was signed to operate and it is only, let's say, dealing in maize or beans, that company was never allowed to contract in any other business. That you were tied. You are only handling the business of beans. You cannot go into any other business. And if you went into any other business at the time, you were acting ultra vires. They would say that company is acting ultra vires, simply because you are now working on objectives which were not made for your company. But however, with the growth and development, today a company can have more than one objective, can operate in different areas. Of course, you signing of the memorandums of associations and all those other things. So as you look at capacity to contract, don't fail to go and look at capacity of corporations to contract, and also capacity with people of unsound mind and capacity of minors. I wanted to throw a little light on that, but we thank you so much for always watching Law School Made Easy at Law School Made Easy 256. Share, subscribe, and like our videos. Thank you. Stay blessed.